So, y'all know we've been going over the court cases that gave our LGBTQIA plus siblings basic rights, right? Right? And this week, we've been talking about the ones that said, hey, let's treat them like we treat anybody else because, they're human beings too. Silly. And as I was reviewing one of the other court cases, I said, self, I really hope somebody who is smarter than me, somebody who actually went to law school, is maybe listening and saying, I wonder if any one of these things applies to the transgender bans that have been passed in the last few years, and says, I wonder if, I don't know, these bans are unconstitutional due to violating the due process clause under the 5th and 14th Amendments, or possibly the equal protection clause of the 14th Amendment. This is just me, myself, and I asking this question because I don't know. I did not go to law school. I'm just reading cases off of the internet and seeing the similarities from all of these cases and all the laws that have been passed. What do I know? With that in mind, let's talk about today's case, which is Bostock versus Clayton County, the court case that said that it was illegal to fire someone just because they are gay or transgender. Picture it, 2003, Clayton County, Atlanta. This is where we find Gerald Bostock. He's an employee of its juvenile court system. During his 10-year career with Clayton County, Bostock received positive performance evaluations and numerous accolades. Early in 2013, Bostock joined a gay softball league and he promoted it at work for volunteerism. Bostock, though, received criticism for his participation in the league and for his sexual orientation. During a meeting where his supervisor was present, someone makes a disparaging remark about his sexual orientation, as well as his participation in the gay softball league. While this is going on, there's an audit of the program funds he managed. They end up firing him for conduct unbecoming a county employee. Pretty vague reason to fire him, don't you think? Bostock's not stupid. We're not stupid. It's pretty clear he was fired because he was gay. In 2016, he sues for workplace discrimination in the United States District Court for the Northern District of Georgia. Now, Georgia has no law protecting LGBTQIA plus people in place. The case was dismissed based on the fact that the Civil Rights Act does not include protection against discrimination towards sexual orientation. Well, that's unacceptable for Bostock, and it's unacceptable for me. He appeals to the 11th Circuit in 2018. The 11th Circuit upheld the ruling and dismissed the Supreme Court precedent set in Price Waterhouse and Onicle, which said that LGBTQIA plus people were protected under Title VII of the Civil Rights Act. You remember, we talked about Onicle versus Sundowner. It said that it prohibited discrimination in employment based on sex. Right? Right. Now, what made it worse was that the 11th Circuit created a circuit split. It conflicted with several other circuits. The 2nd Circuit, the the Second Circuit, the Seventh Circuit, and the Sixth Circuit. So the Second Circuit and the Seventh Circuit in 2018, Zarda versus Altitude Express and Hively versus Ivy Tech Community College of Indiana, both those courts said that discrimination in employment on the basis of sexual orientation violated Title VII of the Civil Rights Act. The Sixth Circuit, they said in R.G. and G.R. Harris Funeral Homes, Inc. versus Equal Employment Opportunity Commission that Title VII covered our transgender siblings, right? So it looks like everybody was on the same page except the 11th Circuit. And can we take a minute to talk about the audacity of the 11th Circuit Appeals Court overriding the Supreme Court? Can we take a minute and talk about that? Now, since we have a circuit split, Bostock was like, I'm sorry, how come everybody else can have nice things but me? And hey, Supreme Court, didn't you already say that the LGBTQIA plus was covered under Title VII under the Civil Rights Act of 1964? Huh? So, briefs are coming in from everywhere and everyone, including Amazon, Coca-Cola, Walt Disney Company. They were like, it's whatever. It's not unreasonably costly or burdensome for us to make sure that we don't discriminate against the LGBTQIA plus. We already don't discriminate against blacks and women, in theory. What's one more protected class? We'll talk about protected class later. Hold on, okay? And the Justice Department argued that technically, sexual orientation was not a protected class, but Congress could legislate it, it's whatever. Employers could, offer more protection, it's whatever, right? So, the Supreme Court is reviewing it. If it was me, I would have attitude. I'd be like, I'm sorry, 11th Circuit, you have some nerve. Because I'm pretty sure we decided this already, like, not that long ago. So, the audacity. In a 6-3 decision, the Supreme Court ruled that an employer who fires an individual employee merely for being gay or transgender violates Title VII of the Civil Rights Act of 1964. The Supreme Court said that discrimination on the basis of homosexuality or transgender status requires an employer to intentionally treat employees differently because of their sex, the very practice that Title VII prohibits in all manifestations. Justice Neil Gorsuch wrote, "An employer who fires an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. Sex plays a necessary and undisguisable role in the decision, exactly what Title VII forbids." Now, of course, Alito, Kavanaugh, and Thomas dissented, but then they would, wouldn't they? Regardless, this case was one more step in preventing our LGBTQIA plus siblings from being fired for who they are. What a concept. Not getting fired for non-job related reasons. Mind-blowing.